electorate if we get it wrong. Thank you, Mr. Speaker.
David Clendon.
Thank you, Mr. Speaker. I'm pleased to take just a brief call to affirm the Greens' support for this legislation. In common, I think, with other parties, we see that it's necessary and an important piece of a bill to go ahead. On the face of it, it's actually quite a technical bill. It clarifies some definitions. It seeks to interpret some legal terms, to provide statutory guidance. And it is a technical bill, but equally, of course, it has some quite profound and significant constitutional implications in terms of the clarification and in terms of what it enables. I think it will attract some fairly high-powered submissions to this select committee, and I think it's a good thing. And I do echo Mr. Parker's comments that I think the Privileges Committee is, in terms of the personnel, are well suited to hear some of the arguments that no doubt it will generate. There's a fair bit of intellectual horsepower on that committee, not least of all, I dare say, my own Green colleague, Dr. Kennedy Graham. There's a lot of experience there, and I think we'll observe with interest just how this committee and its deliberations rolls out. Sir, it's in a sense unusual in that this legislation responds directly to a single court decision, a Supreme Court decision, and it seeks to restore what was understood within Parliament as being the status quo, the understanding that was indeed reinforced by none other than our parliamentary Bible, McGee. Of course, the Supreme Court judgment and its wisdom took odds with McGee and was not persuaded by his position. But nevertheless, as I say, it does effectively avoid doubt, or seeks to remove any doubt about exactly what are the boundaries of privilege, absolute privilege compared with the limited or qualified privilege that was referred to. It is referring to some fairly old legislation. The point's been made, Article 9 of the Bill of Rights of 1688, which is archaic in its language perhaps, but we ought to remember, of course, that a lot of our current day democracy, a lot of our constitutional arrangements still rest on that. And even the theatre, dare I say it, of each opening of Parliament, where the Speaker is reluctantly dragged to the chair, reflects historically that it was an uncomfortable chair to sit in if a monarch chose to take umbrage at something the Parliament had done, when the boundaries between the monarchy and the Parliament were not quite so clearly defined. And I do think it's important that we do reflect that we ought never to take our democracy for granted. And I think this bill is an expression of that we do not want to take democracy for granted. So I think it's interesting that in the Supreme Court judgment in Lee versus Gower, they made reference to an instance in UK where some British members of Parliament sought to use the protection of parliamentary privilege in a way that I think certainly was found to be unconstitutional, even unethical. The accusation was that these MPs had presented fraudulent expense claims. And the court in UK, I think, found quite rightly that parliamentary privilege certainly did not extend to that absurd position where it could be used to protect people from illegal activities, or indeed at least the accusation. I believe that is still the case in the Russian Parliament, in fact, that being an MP from Russia does give one an absolute exemption from any sort of legal accusation from being taken to court, with the result, of course, that there's all sorts of rogues in that Parliament simply so they can conduct their illegal activities with complete protection from the law. And, of course, that would be a very undesirable situation to be into. Sir, I do think that I mention that because I do think that while parliamentary privilege does give us considerable leeway, I think the lesson from this case, and indeed from the Supreme Court decision, is that privilege is a power that we as MPs ought to use with the utmost responsibility, with the utmost discretion. We should respect the fact that it is an extraordinary privilege in both meanings of the words to be able to make accusations, even to make statements that outside of this place would be deemed to be defamatory. And I think the compelling lesson or the obligation on us is to exercise that privilege with the utmost integrity, not to use it lightly, not to use that power in any way that could bring the notion of privilege into disrepute, because it is something that's embedded in our democracy. We toy with it at our peril, and I would hope that no member of this House would use privilege in that way. Sir, I don't think there's much more to be said. I would just reiterate that I do think it's going to be an interesting committee. There will be some fairly in-depth and well-informed submissions made to the committee, I have no doubt. And I do think, however, with goodwill, that we will find a satisfactory outcome. Mr Parker again made reference to the fact that there is we know and we respect the separation of powers and authority between judiciary and parliament. There is always a little bit of grey area there. I think there's often a tension between the relative roles of the judiciary and parliament, and that's not necessarily an unhealthy thing. But I do think that to the extent that this legislation is intended to make clear where some of those boundaries lies, that it's useful, it's timely, and we look forward to it going further through the House. Kia ora.
Dear Sir Rourke.